Oh, Ginger Snap, you're so silly. Quick rules of thumb. Number one, if you see a Mark Stevens-esque gish gallop of quotes out of cases supporting something as demonstrably wrong as that you can drive without a driver's license, then you may want to actually take the time to read the cases. Had Mr. Freeman taken the time to try to read some of these cases, reading's hard, he may have not posted this. The very first quote doesn't appear in the case, Thompson v. Smith. This is Thompson v. Smith. Let's do the short title. There's Thompson v. Smith. You can see that it is, all these cases have two names. This is the state title, 155 VA 367. It's also 154 SE 579. They're all published in like two places at least. So just a different publication. Let's see. We're going to find something in here. Let's see. We're going to just do that. We're just going to do that little section right there. All right. Bling! Doesn't exist. So this is the closest thing to the quoted text, the right of a citizen to travel on the public highways and transport his property thereon in the ordinary course of life and business is a common right, which he has under his right to enjoy life, liberty, etc. But then if you continue reading, the regulation of the exercise of the right to drive a private automobile on the streets of the city may be accomplished in part by the city granting, refusing, and revoking under the rules of general application permits to drive an automobile on its street. This case was all about a guy who, this is way back in the day when the city would grant a permit to drive in the city. And the guy got his license, his permit revoked because of the arbitrary and capricious nature of the statute that allowed the chief of police to revoke his. Chief of police is authorized to and directed to revoke the permit of any driver who, in his opinion, becomes unfit to drive an automobile on the streets of the city. That's arbitrary and capricious. That's what this case is about. It's not about you have a right to drive without a license. It is saying that you have a right to not have your license taken away from you in an arbitrary and capricious manner. It is procedural due process. If the state grants you something, like if they grant you disability, they can't revoke your disability payments from you without a hearing, without some sort of due process. Same thing with the license. They can't revoke your license without some form of due process. The next case he quotes is, I think, the same text, but it's from Teche Lines v. Danforth. Teche Lines v. Danforth. And this is a good thing from Teche Lines v. Danforth. The rights aforesaid being fundamental are constitutional rights, and while the exercise thereof may be reasonably regulated by legislative act in pursuance of the police power of the state, and although those powers are broad, they do not rise above the privileges which are embedded in the constitutional structure, the police power cannot justify the enactment of any law which amounts to an arbitrary and unwarranted interference with or unreasonable restriction on the rights of citizens which are fundamental. The state can regulate it. They just can't take it away from you for arbitrary and capricious decisions. In this case, they were talking about stopping distances. You had to maintain 20 feet or something like that. And in this case, it was impossible. I think they were moving a house on the road or something like that. Yeah, so they're like, this, or they're moving something on the road that they couldn't do it. And the court said that if it's impossible to comply, then it's impossible to comply. And the example that they used was a guy who got a ticket for driving without tags, but it was going to be 3 months before the state got tags in. So it wasn't his fault that he didn't have tags. Anyway, again, it's not about you have a right to drive without a license. This case is about 20 feet clearance in front of a bus. Yeah. If it's, yeah. Anyway, so no, sorry, it doesn't work. Next one was white. So CalApp and CalReporter. CalReporter is a Westlaw version. CalApp is what California publishes into. And then it's put into CalReporter by Westlaw. The right of the citizen to drive on the street without freedom from public interference, or with freedom from police interference. Again, this case does not have the quoted text. I'm going to copy it. This is this one. Control F, Control V. Bling! It's not there. This case is about a prostitute who was convicted of prostitution. As part of her conviction for prostitution, she wasn't allowed to be within certain bounded areas on the map. And those bounded areas were areas that were known for prostitution activity. And in this case, the court said that you can't just say she wasn't allowed to go there. It's not that she wasn't allowed to drive there. She wasn't allowed to go there, period. She wasn't allowed to be there. She would get arrested if she was within those bounded areas of the map. And the court said you can't do that. You can't do that. The right to travel says that people can go there. Like if you have family there, you can visit your family there. So the court said you can put these restrictions on where she can be if you tailor it a little more closely to preventing the activity. Like if you say you can't be out on the street between these hours at these map locations, that would probably be fine. Or you have to be able to show some legitimate purpose. You can't just arrest somebody for being within those map areas because like you're on a street. It'd be different, like trespass from a property location. You can't be on that property. That's fine. But you can't say you're trespassed from the street. You know what I mean? Anyway, so it doesn't have anything to do with it. And the quoted text wasn't there. So yeah, this does not support a right to travel without a license. Let's see what we got next. That was white. Caneisha Mills VDC. It's a very similar one. I don't even know. I didn't even check to see if the quoted text is present. It might be. All right, so it looks like it is. So anyway, in this one, the NSE is the neighborhood safety zone, and the reason why this got to court isn't because she was like trying to drive without a license. It's because what the police were doing is they're creating these neighborhood safety zones, and they were not allowing people who didn't live there to go there. And they were trying to do that to prevent people from like driving into neighborhoods, dealing drugs and things like that, I guess. And again, what the court said is that you can't stop people. Like they may have family who lives in that area and they want to go visit their family or friends. And you can't just keep them out of there because they don't live there. You can't do that. If it is a public street, they have the right to go down that street. Again, it's not about driving without a license. This has nothing to do with the driver's license. I guess it does have something to do with the driver's license. You have to show that you live on the street. But it's, yeah, so legitimate reasons were these. But notice it wasn't like if you have family living there, if you wanted to visit a friend. So they said that you can't do this. This is too strict. You're violating their right to travel. Nothing to do with driving without a driver's license. Let's see what the next one is. It's Berberian v. Lussier. Berberian v. Lussier. I didn't even check to see if this one has the stated language in it. Whatever may be its nature, the right to use public highways for travel by motor vehicles is one which properly can be regulated by the legislature in the valid exercise of police powers of the state. Financial responsibility statutes have been held to constitute a reasonable regulation of the public highways and a proper measure for protecting the public safety. So this is talking about requiring people to have insurance. My dog is dragging her butt across the carpet. I hate that. You're leaving butt stains across my carpet. Yes, this is Berberian v. Lussier. It doesn't do you any good there, bub. Then the next one was Schlechter. We were at Berberian, and then there's Schlechter. This is again another one where they didn't have insurance. And in this day, when the motor vehicle is such an important part of our modern daily living, the use of the vehicle is so essential to both livelihood and enjoyment of life. This court recognizes that the use of public highways is a right which all qualified citizens possess. All qualified citizens possess. Subject, of course, to reasonable regulation under the police power of the sovereign. They can require you to have a driver's license. And finally, last but not least, we have Adams v. City of Pocatello. The right to operate a motor vehicle, an automobile, upon the public streets and highways is not a mere privilege. It is a right of liberty, the enjoyment of which is protected by the guarantees of the federal and state constitutions. Interesting. And then look, it's there. The right to operate a motor vehicle upon the public streets and highways is not a mere privilege. It is a right or liberty, the enjoyment of which is protected by the guarantees of the federal and state constitutions. And then you keep reading. It's important to keep reading. The right of a citizen to operate a motor vehicle upon the public streets and highways is subject to reasonable regulation by the state in the exercise of its police power. Anyway, it's all nonsense. James Freeman, read the cases before you cite them. Your gish gallop of nonsense is nonsense. You should feel bad. You're misleading people. You are holding yourself out to be the sovereign citizen that we are very much afraid that you are. I am glad that you're talking about attorneys and things like that, but maybe you should listen to attorneys because maybe they know something you don't. Thanks for watching. Have a great morning.